Banks and Specialized Deposit-Taking Institutions. Act, 2016. Act 930. Application of this Act. Section 1. 1. This Act applies to a. Banks. b. Specialized deposit-taking institutions. c. Financial holding companies, and d. Affiliates of banks, specialized deposit-taking institutions and financial holding companies. 2. This Act does not apply to credit unions which are subject to licensing and supervision under the Non-Bank Financial Institutions Act. 2008 Act 774. Application of Act 992. Section 2. 1. This Act shall be read together with the Companies Act, ACT 992, and shall not except as otherwise provided in this Act derogate from the provisions of that Act. 2. Where there is a conflict or inconsistency between the Companies Act, ACT 992, and this Act shall prevail. Role of the Bank of Ghana. Section 3. 1. The Bank of Ghana shall have overall supervisory and regulatory authority in all matters relating to deposit-taking business. 2. For the purpose of subsection 1, the Bank of Ghana is responsible for a. Promoting the safety and soundness of banks and specialized deposit-taking institutions. b. Considering and proposing reforms of enactments relating to deposit-taking business. c. Ensuring the soundness and stability of the financial system and the protection of depositors in the country through the regulation and supervision of financial institutions. d. Developing appropriate consumer protection measures to ensure that the interest of clients of the banks and the specialized deposit-taking, protected, and institutions are adequately e. Dealing with unlawful or improper practices of banks and specialized deposit-taking institutions. 3. The supervisory functions of the Bank of Ghana under this Act shall be carried out through the supervisory structures established by the Bank of Ghana. 4. The Bank of Ghana may authorize the heads of the supervisory structures or any other person to exercise a power and do an act that the Bank of Ghana considers appropriate in order to discharge the responsibilities of the Bank of Ghana under this Act. 5. In accordance with the Bank of Ghana Act, 2002, Act 612, the Bank of Ghana may appoint an authorized agent to carry out specified activities of a particular tier or category or class of specialized deposit-taking institutions on behalf of the Bank of Ghana. 6. For the purpose of this section, authorized agent includes an apex body, network, industrial association, self-regulatory organization or any other person recognized by the Bank of Ghana. Deposit-taking business. Section 4. 1. Subject to this Act, a person shall not carry on a deposit-taking business in or from within the country unless that person is a body corporate formed under the laws of this country. 2. A person that is not a body corporate formed under the laws of the country may, with the prior written approval of the Bank of Ghana, carry out a deposit-taking business in or from within the country. 3. A person shall not propose to be a shareholder of a deposit-taking microfinance institution unless that person is a citizen. 4. The Bank of Ghana shall issue directives to govern the operations of persons exempted under subsection 2. 5. For the purpose of this Act, deposit-taking business means the business of a. Taking money on deposit and making loans or other advances of money, and b. Financial activities prescribed by the Bank of Ghana for purposes of this definition. Licensing Authority of Bank of Ghana. Section 5. The Bank of Ghana shall have the sole responsibility for a. The issuance of licenses to banks and specialized deposit-taking institutions. b. Granting approval to foreign banks with respect to the establishment of representative offices, and C. The registration of financial holding companies. Requirement of a license. Section 6. 1. A person shall not accept a deposit from the general public or carry on a deposit-taking business in or from within the country without a license issued in accordance with this Act. 2. The Bank of Ghana may prescribe classes of liabilities that constitute deposits. 3. Where it is uncertain in a particular case whether a particular liability of a bank or specialized deposit-taking institution is to be regarded as a deposit, the Bank of Ghana shall determine whether that liability is a deposit. 4. A person shall not use a license under this Act for a purpose other than that for which the license is issued. Application for license. Section 7. 1. A person who seeks to carry on a deposit-taking business shall apply in writing to the Bank of Ghana for a license. 2. An application for a license under subsection 1 shall be accompanied with the following: A certified true copy of the company regulations or other relevant instrument relating to the proposed bank or specialized deposit-taking institution under which the person proposing to carry on a deposit-taking business was established. B. The names, addresses, occupations, business and professional history, certified financial positions, and corporate affiliations of the significant shareholders and the respective values of the shares. C. Where the bank or specialized deposit-taking institution is a member of a corporate group. 1. A complete organizational structure including a diagram of the group. 2. Direct and indirect affiliates and associates of the bank or specialized deposit-taking institution, and 3. The nature of the relationship to the group. D. The particulars of the proposed directors and key management personnel concerned with the management of the deposit-taking business, including 1. Their qualifications and experience. 2. Business and professional history for the preceding 10 years or a longer period that the Bank of Ghana may determine. 3. Certified financial position. 4. Business interest, and 5. The performance of the business concerns under their control or management. E. Feasibility report including a business plan and financial projections for the first 5 years and tied area of activity intended. F. Documentary evidence of the capital of the proposed bank or specialized deposit-taking institution, including the original sources of funds and any other source of funds. G. In the case of a foreign applicant. 1. An authenticated copy of the certificate of incorporation and the company regulations or other relevant instruments and bylaws or similar documents, and 2. A written confirmation from the supervisory authority in the country of incorporation of the applicant or head office, if different, that the supervisory authority has no objection to the proposal of the applicant to carry on a deposit-taking business in the country and that supervisory authority exercises global consolidated supervision over that bank or specialized deposit-taking institution. H. A statement on measures and structures that the applicant intends to adopt to ensure that business is conducted in accordance with sound corporate governance principles. 1. A statutory declaration for each proposed director, key management personnel and significant shareholder of the proposed bank or specialized deposit-taking institution, disclosing, where applicable, 1. A conviction for an offense by a court of competent jurisdiction. 2. A personal bankruptcy filing. 3. A disqualification from practicing a profession, or 4. A past or present involvement in a managerial function of a body corporate or other undertaking that is subject to insolvency or liquidation proceedings. J. The processing fee that the Bank of Ghana may by notice specify, and k. Any other particulars that the Bank of Ghana may require. 3. An application for a license shall indicate clearly the type of license that is being applied for. 4. The Bank of Ghana may, for the purpose of verifying the particulars submitted under subsection 2. A. Interview a promoter, proposed director or key management personnel in the course of the verification, and b. Inspect the books, records, and premises intended for use by the bank or specialized deposit-taking institution. 5. Where a document submitted to the Bank of Ghana is not in the English language, the document shall be accompanied with a certified translation in English. 6. The Bank of Ghana may require that information supplied to the Bank of Ghana be verified, certified, or otherwise authenticated in the manner that the Bank of Ghana may prescribe. 7. The Bank of Ghana shall a. Within 10 working days of the receipt of an application, acknowledge in writing the receipt of the application, and b. Within 6 months after the receipt of an application, communicate its decision in writing to the applicant. 8. Despite paragraph b of subsection 7, where the Bank of Ghana is of the opinion that further investigation or information is required to process the application, the Bank of Ghana shall within a reasonable period after the 6-month period specified under paragraph b of subsection 7, notify the applicant and subsequently inform the applicant in writing of the decision of the Bank of Ghana. Types of licenses. Section 8. 1. A license issued under this Act shall be issued subject to the terms and conditions that the Bank of Ghana may impose. 2. The terms and conditions of a license may be stated in the notice of approval of a license and shall be considered to form part of the license for purposes of this Act. 3. A license shall be designated either as a banking license or a specialized deposit-taking institution license. 4. A specialized deposit-taking institution license shall be issued to an applicant whose primary activities are limited to deposit-taking business. 5. The name of a specialized deposit-taking institution shall clearly designate which category of specialized deposit-taking institution license that institution operates under, in accordance with rules prescribed by the Bank of Ghana. 6. For purposes of this Act, the Bank of Ghana shall by notice published in the Gazette or in at least 2 daily newspapers of national circulation indicate the designation of a license issued to a company before the coming into force of this Act. Prerequisites for a license. Section 9. The Bank of Ghana shall not issue a license to an applicant unless the Bank of Ghana is satisfied that a. The feasibility report submitted by the applicant under Section 7 is based on sound analysis under reasonable assumptions. b. The proposed directors and key management personnel of the applicant are fit and proper persons. c. The significant shareholders are suitable and the ownership structure of the proposed bank or specialized deposit-taking institution will not hinder effective supervision, including supervision on a consolidated basis. d. The paid-up capital of the applicant is adequate and the original sources of capital are acceptable and do not include borrowed funds. e. The arrangements for governance, including accounting, risk management, and internal control systems and records of the applicant are adequate. f. The applicant is not a shell company, and g. The applicant has complied with this Act, the regulations, directives, and other legally binding instruments made under this Act and any conditions that the Bank of Ghana may impose. Provisional approval. Section 10. 1. Without limiting Section 9, the Bank of Ghana may issue a provisional approval of a license for a subsidiary of a foreign bank or specialized deposit-taking institution if the Bank of Ghana is satisfied that a. The foreign bank or specialized deposit-taking institution is adequately supervised on a global consolidated basis by the home country supervisor of that bank or specialized deposit taking institution, and b. Arrangements for cooperation, coordination, and information sharing with the home country supervisor are in place. 2. The Bank of Ghana may issue a provisional approval for a specified license to an applicant on the terms and conditions that the Bank of Ghana considers appropriate, if the Bank of Ghana is satisfied that a. The applicant will carry on business with integrity, prudence, and the required professional competence. b. The applicant has and will maintain an unimpaired paid-up capital as specified in Section 28 and holds a license of the specified type as required, and c. Where the applicant is a subsidiary of a foreign company, the applicant will maintain within the country the required capital in the form of funds transferred from abroad together with other funds that may be determined by the Bank of Ghana. 3. The Bank of Ghana may vary the requirements under paragraph b. of subsection 2, in the case of a rural or community bank or any other specialized deposit-taking institution that the Bank of Ghana may determine. 4. Where the bank or specialized deposit-taking institution fails to comply with the terms and conditions of the provisional approval within 1 year of the provisional approval shall lapse. 5. Despite the issuance of a provisional approval under subsection 1, the Bank of Ghana may in writing withdraw the provisional approval if additional information subsequently made available to the Bank of Ghana justifies the withdrawal. Skip Section 11. Final approval and issuance of banking or specialized deposit-taking institution license. Section 12. 1. The Bank of Ghana may grant the applicant a final approval and issue a license to carry on a deposit-taking business of a specified type, where the Bank of Ghana is satisfied a. with the organizational and infrastructural arrangements made by the applicant, b. that the applicant has complied with the terms and conditions stipulated in the provisional approval, and c. that the prerequisites of a license specified in Section 9 have been met. 2. The holder of a license issued under this Act shall, in addition to the processing fee for the application of a license, pay to the Bank of Ghana a. an initial license fee, and b. the annual license fee that the Bank of Ghana may by notice specify. 3. The Bank of Ghana shall notify the institution responsible for deposit protection of the issuance of a license to a bank or specialized deposit-taking institution. Non-transferability or assignment of license. Section 13. 1. A license issued by the Bank of Ghana shall not be transferred or assigned. 2. A person who transfers or assigns a license issued by the Bank of Ghana commits an offense and is liable on summary conviction to a fine of not less than 2,000 penalty units and not more than 4,000 penalty units. Conditions for issuance of license. Section 14. 1. A license issued under this Act shall be subject to the conditions that the Bank of Ghana may impose, including a. membership of the Ghana Deposit Protection Scheme, and b. the activities in which the bank or specialized deposit-taking institution is permitted to engage in. 2. The Bank of Ghana may amend or vary a condition attached to a license issued to a bank or specialized deposit-taking institution. 3. The Bank of Ghana shall, before taking an action under subsection 2, notify the bank or specialized deposit-taking institution concerned in writing. 4. Where a bank or specialized deposit-taking institution is dissatisfied with the decision of the Bank of Ghana, that bank or specialized deposit-taking institution may, within 7 days of receipt of the notice, make a representation in writing to the Bank of Ghana. 5. The Bank of Ghana shall, after considering the representation made by the bank or specialized deposit-taking institution, take a decision and Notify the bank or specialized deposit-taking institution concerned of the decision made. Refusal of license. Section 15. 1. The Bank of Ghana may refuse an application for a license to carry on deposit-taking business where, in view of the prevailing conditions in the banking and specialized deposit-taking institution sector, or in keeping with the policy on banks and specialized deposit-taking institutions, the Bank of Ghana is not satisfied with the merits of the application. 2. Where the Bank of Ghana refuses an application under subsection 1. The Bank of Ghana may give reasons in writing for the refusal of the application. Revocation of license. Section 16. 1. The Bank of Ghana may revoke a license issued under Section 12. Where a. The Bank of Ghana is satisfied that an applicant provided false, misleading or inaccurate information in connection with the application for a license or suppressed material information. B. The bank or specialized deposit-taking institution fails to commence business within 1 year from the date the license was issued. C. The bank or specialized deposit-taking institution fails to fulfill or comply with the terms and conditions stipulated in the license. D. The bank or specialized deposit-taking institution carries on business in a manner which is contrary or detrimental to the interest of depositors or the public. E. The bank or specialized deposit-taking institution has been convicted by a domestic court or any other court of competent jurisdiction of a crime related to money laundering or terrorist financing, or is an affiliate or subsidiary of a parent or holding company which has been so convicted. F. In the judgment of the Bank of Ghana, the bank or specialized deposit-taking institution engages in unsafe or unsound practices, or G. The bank or specialized deposit-taking institution persistently contravenes this act, the regulations, directives, or orders made under this act. 2. Subsection 1 does not limit the power of the Bank of Ghana to take any other remedial or penal action against a bank or specialized deposit-taking institution. 3. Where the Bank of Ghana proposes to revoke the license of a bank or specialized deposit-taking institution under subsection 1, the Bank of Ghana shall a. Give notice in writing to the bank or specialized deposit-taking institution. B. Specify the proposed action and the grounds on which the action is proposed to be taken, and C. Give the bank or specialized deposit-taking institution an opportunity to make a written representation within 30 days of the service of the notice. 4. After the expiry of the notice period and considering any representations made by the bank or specialized deposit-taking institution, the Bank of Ghana may a. Decide whether to take the proposed action, or b. Vary the proposed action as the Bank of Ghana considers appropriate, and c. Communicate the decision of the Bank of Ghana to the bank or specialized deposit-taking institution. 5. Where the Bank of Ghana revokes the license of a bank or specialized deposit-taking institution, that bank or specialized deposit-taking institution shall cease to carry on the deposit-taking business if the bank or specialized deposit-taking institution has already commenced business and shall surrender the license. 6. A revocation of the license of a bank or specialized deposit-taking institution shall have immediate effect. 7. Despite subsections 3 and 4, the Bank of Ghana may, in cases of emergency or in the public interest, revoke the license of a bank or specialized deposit-taking institution without notice. 8. Where a license is revoked under this section, the Bank of Ghana shall immediately initiate a receivership as provided in sections 123 to 139 and notify the institution responsible for deposit protection. Skip section 17. Permissible activities. Section 18. 1. A bank or specialized deposit-taking institution shall not carry on A business other than any of the following. A. Acceptance of deposits and other repayable funds from the public. B. Lending. C. Financial leasing. D. Investment in financial securities. E. Money transmission services. F. Issuing and administering of means of payment including credit cards, traveler's checks, banker's drafts and electronic money. G. Guarantees and commitments. H. Trading for own account or for account of customers in 1. Money market instruments. 2. Foreign exchange, or 3. Transferable securities. 1. Participation in securities issues and provision of services related to those issues. J. Advice to undertakings on capital structure, acquisition and merger of undertaking. K. Portfolio management and advice. L. Keeping and administration of securities. M. Credit reference services. N. Safe custody of valuables. O. Electronic banking. P. Payment and collection services. Q. Bancassurance. R. Non-interest banking services, and S. Any other services that the Bank of Ghana may determine. Skips the remaining subsections under Section 18. Restrictions on commercial, agricultural or industrial activities and immovable property. Section 19. 1. Subject to subsection 2. A bank, specialized deposit taking institution or financial holding company shall not engage directly in a commercial, agricultural or industrial undertaking. 2. Subject to the limits that the Bank of Ghana may prescribe, a bank, specialized deposit-taking institution or financial holding company shall not build, purchase or take a lease of immovable property except a. For the provision of business premises, or for the purpose of housing the staff of the bank or specialized deposit-taking institution, or b. For the provision of amenities for staff. 3. Despite subsection 2, a bank, specialized deposit-taking institution or financial holding company may accept immovable property as collateral security for a debt or other liability and may acquire an interest, which a bank, specialized deposit-taking institution or financial holding company may lawfully acquire in the satisfaction of a debt due that bank, specialized deposit-taking institution or financial holding company. 4. An interest acquired under subsection 3 shall be disposed of by the bank, specialized deposit-taking institution or financial holding company within 1 year after the acquisition or within a longer period that may be determined by the Bank of Ghana on application made by the bank, specialized deposit-taking institution or financial holding company. 5. Subject to the limits that the Bank of Ghana may prescribe, a bank, specialized deposit-taking institution or financial holding company may let or sublet a part of immovable property which is ordinarily used for business where the property is in excess of the immediate requirements of the bank, specialized deposit-taking institution or financial holding company. 6. A bank, specialized deposit-taking institution or financial holding company which contravenes a provision of this section is liable to pay to the Bank of Ghana an administrative penalty of 1,500 penalty units and for each day that the contravention continues, an additional penalty of 200 penalty units. Skip sections 20 to 22. Use of the word bank. Section 23. 1. Except as otherwise provided for in this Act, a person, other than a company holding a banking license, shall not hold itself out as a bank or use the word bank or any of its derivatives in any language, or any word that sounds like a bank in the description or title under which that person is carrying on financial services business in Ghana, or make a representation to this effect in any billhead, letter, paper, notice, advertisement or in any other manner. 2. The use of the word bank in the name of an association of banks, or of employees of a bank formed for the promotion of mutual interest of its members shall not be construed as a contravention of subsection 1. 3. Despite subsection 1, a specialized deposit-taking institution that is licensed as a rural or community bank may use the term rural bank or community bank. 4. The Bank of Ghana may prescribe similar restrictions on the use of terminology related to other classes of specialized deposit-taking institutions. 5. A specialized deposit-taking institution shall in all correspond denke, publications and advertisements, use the full name of that specialized deposit-taking institution as stated on the license issued by the Bank of Ghana. 6. The Bank of Ghana may order a person who contravenes this section to cease using the terminology that caused the contravention and to change the name under which that person operates. 7. A person who contravenes this section is able to pay to the Bank of Ghana an administrative penalty of 1,500 penalty units. Skip sections 24 to 57. Disqualification of a director and key management personnel. Section 58. 1. A person shall not be appointed or elected or accept an appointment or election as a director or key management personnel of a bank, specialized deposit-taking institution or financial holding company if that person A. has been adjudged to be of unsound mind or is detained as a person with a mental disorder under any relevant enactment. B. Has been declared insolvent or has entered into agreement with another person for payment of the debt of that person and has suspended payment of the debt. C. Has been convicted of an offense involving fraud, dishonesty, or moral turpitude. D. Has been a director, key management personnel or associated with the management of an institution which is being or has been wound up by a court of competent jurisdiction on account of bankruptcy or an offense committed under an enactment. E. Is a director or key management personnel of another bank, specialized deposit-taking institution or financial holding company in the country. F. Is below the age of 18 years. G. Does not have the prior written approval of the Bank of Ghana, or H. Has defaulted in the repayment of the financial exposure of that person. 2. A bank, specialized deposit-taking institution or financial holding company which has knowledge or is aware of a circumstance that subjects a director or key management personnel to disqualification under subsection L, shall promptly notify the Bank of Ghana. 3. Where a person becomes disqualified under subsection 1, that person shall immediately cease to hold office as a director or key management personnel and the bank, specialized deposit-taking institution or financial holding company shall immediately terminate the appointment of that person. 4. A person who contravenes subsection 1 is liable to pay to the Bank of Ghana an administrative penalty of 1,000 penalty units. 5. Subsection 1e does not apply where a person appointed as a director of the ARB Apex Bank Limited is a director of a rural or community bank. B. A person appointed as a director of a rural or community bank is a director of another bank, or C. In the opinion of the Bank of Ghana, special circumstances require that the person is appointed as a director of another bank, specialized deposit-taking institution or financial holding company. Skip sections 59 and 60. Prohibition of an advance against security of own shares. Section 61. 1. A bank or specialized deposit-taking institution shall not grant an advance, loan or credit facility including a guarantee against the security of a. The shares of that bank or specialized deposit-taking institution. B. The shares of the financial holding company. C. The shares of a subsidiary of that bank or specialized deposit-taking institution, or D. The shares of a subsidiary of the financial holding company. 2. A bank or specialized deposit-taking institution shall not issue shares that are paid for by funds borrowed from that bank or specialized deposit-taking institution. 3. A transaction carried out in contravention of subsections 1 and 2 is void. 4. A director or key management personnel who contravenes subsection 1 or 2 is personally liable to pay to the Bank of Ghana an administrative penalty of 2,500 penalty units. Limits on financial exposure. Section 62. 1. A bank or specialized deposit-taking institution shall not take financial exposure in respect of a person or a group of connected persons which constitutes in the aggregate a liability amounting to more than 25% of the net own funds of that bank or specialized deposit taking institution or a lower percentage that the Bank of Ghana may prescribe. 2. For purposes of subsection 1, an unsecured financial exposure shall not exceed 10% of the net own funds of a bank or specialized deposit-taking institution. 3. For the purpose of this section, 2 or more persons constitute a group of connected persons if a. A direct or indirect control relationship exists among them. B. Any other relationship exists to the extent that the financial soundness of any of them may affect the financial soundness of the other person. C. The same factors may affect the financial soundness of some persons or the group, or D. As a result of the structure of their relationship, the other person is ultimately responsible for or benefits from the financial exposure outstanding. 4. For the purpose of this section, the Bank of Ghana A. May provide guidance for banks and specialized deposit-taking institutions in determining whether a connection exists among a group of persons, and B. Shall, where it is uncertain that a connection exists, determine if a connection exists on an individual basis, based on the facts and circumstances of a group of persons. 5. The Bank of Ghana may prescribe that a deposit with a bank outside the country solely for correspondent banking purposes A. Be subject to a higher limit, or B. Be exempt from the application of subsection 1. 6. A bank or specialized deposit-taking institution shall within 5 days A. Report to the Bank of Ghana a financial exposure that exceeds the limits of this section, and B. Provide a written plan for remedying the violation as soon as practicable. 7. The aggregate amount of all large financial exposures of a bank or specialized deposit-taking institution shall not at any time exceed the percentage level of net own funds prescribed by the Bank of Ghana having regard to the risk and vulnerability of the financial system. 8. For the purpose of this section, in computing the financial exposure, the following assets that may be held as collateral shall be deducted. A. Cash deposit. B. Hen on term deposit with the bank or specialized deposit taking institution. C. Market value of treasury bills, government securities, bank securities, and D. Any other security of a similar nature approved by the Bank of Ghana. 9. A financial exposure shall not be considered as secured unless it is adequately secured by a collateral having a market value of at least 120% of the outstanding amount of the exposure throughout the term of the financial exposure. 10. A bank or specialized deposit-taking institution which assumes financial exposure in contravention of this section shall pay to the Bank of Ghana a penalty calculated as the base rate of the bank or specialized deposit-taking institution and a risk premium of 5 percentage points of the overexposure. 11. A director or key management personnel who contravenes a provision of this section is personally liable to pay to the Bank of Ghana an administrative penalty of 2,500 penalty units. Skip section 63. Restrictions on transactions with an affiliate. Section 64. 1. A bank, specialized deposit-taking institution or financial holding company shall not grant or permit to be outstanding a financial exposure in respect of an affiliate of that bank, specialized deposit-taking institution or financial holding company except on terms which are non-preferential in all respects including creditworthiness, term, interest rate and the value of the collateral. 2. A bank, specialized deposit-taking institution or financial holding company shall not take a financial exposure in respect of an affiliate if the aggregate of the financial exposures to the affiliates of the bank, specialized deposit-taking institution or financial holding company exceeds 25% of the net own funds. 3. Despite subsections 1 and 2, the Bank of Ghana may, by order, set a specific limit on a financial exposure to an affiliate on an individual basis, having regard to the circumstances of the bank, specialized deposit-taking institution or financial holding company. 4. A bank, specialized deposit-taking institution or financial holding company which contravenes a provision of this section is liable to pay to the Bank of Ghana an administrative penalty of 2,500 penalty units. 5. A director or key management personnel who contravenes a provision of this section is personally liable to pay to the Bank of Ghana an administrative penalty of 2,500 penalty units. Skip sections 65 to 68. Restrictions on lending to staff. Section 69. 1. A bank or specialized deposit-taking institution shall not lend on preferential terms to an employee of that bank or specialized deposit-taking institution unless the lending is part of a formally approved employment package or employee benefit plan. 2. A bank or specialized deposit-taking institution shall not grant to an employee of that bank or specialized deposit-taking institution an unsecured advance or credit facility, the aggregate amount of which exceeds 2 years total emolument of that employee. 3. The aggregate amount of loans on preferential terms, both secured and unsecured, by a bank or specialized deposit-taking institution to employees shall not exceed 20% of the net own funds of that bank or specialized deposit-taking institution. 4. A bank or specialized deposit-taking institution which grants an advance or credit facility in contravention of this section is liable to pay to the Bank of Ghana a. An amount of money calculated as 1/2 per mil of the overexposure for each day that the overexposure persists, and b. An administrative penalty of not more than 1,000 penalty units. 5. For the purpose of calculating capital adequacy, a financial exposure that is in contravention of this section shall be deducted from capital. 6. For the purpose of this section, the term employee includes a key management personnel other than an executive director. Skip sections 70 to 139. Review of decisions of the Bank of Ghana on licensing. Section 140. 1. Where a person is aggrieved with a decision of the Bank of Ghana in respect of issuance of a license, that person may, within 30 days of the decision, petition the Bank of Ghana in writing for a review. 2. Where the person is dissatisfied with the outcome of the review. Under subsection 1, the person may, within 30 days from the date of the decision, in writing, appeal against the decision to the adjudicative panel established under subsection 3. 3. There is established an adjudicative panel consisting of a chairperson who is a justice of the High Court nominated by the Chief Justice. b. One person with knowledge in banking and finance and with not less than 10 years experience in banking and finance, nominated by the Chartered Institute of Bankers, and c. One member of the Institute of Chartered Accountants, Ghana, who has been in practice for not less than 10 years. Nominated by the Institute of Chartered Accountants, Ghana. 4. The Chief Justice shall appoint members of the adjudicative panel. 5. The adjudicative panel shall adopt its own rules of procedure. 6. The adjudicative panel shall communicate its decision to the applicant within 30 days of receipt of the appeal made to it in writing. Under subsection 2. 7. A person dissatisfied with the decision of the adjudicative panel may appeal to the High Court within 30 days upon receipt of the decision. 8. The expenses of the adjudicative panel, including allowances of members of the adjudicative panel, shall be borne by the Bank of Ghana. Skip section 141 and 142. Unclaimed balances. 143. 1. Where a current or savings account has not been operated for a period of 2 years or a time deposit account has not been operated for a period of 2 years after the date of maturity of the deposit, a withdrawal shall not be made on the account except with the permission of 2. Authorized officers of the bank or specialized deposit-taking institution involved. 2. An account referred to in subsection 1 shall be transferred to a separate register of dormant accounts in the books of the bank or specialized deposit-taking institution, and a notice in writing of that action shall be given to the depositor at the last known address of the depositor. 3. Where an account which is transferable under subsection 2 is subject to a service charge, or is an interest-bearing account, the charge may continue to be levied or the interest accrued up to the date on which the account was transferred to the register of dormant accounts. 4. Where an account is transferred to a register of dormant accounts and the account has been on the register for 3 years, the bank or specialized deposit-taking institution shall advertise in at least 2 daily newspapers of national circulation the fact that the account has been on the register of dormant accounts for 3 years. 5. An account may be transferred out of the register of dormant accounts on a request by the depositor or the legal representative of the depositor where a depositor is dead or incapacitated. 6. Where an account has been in the register of dormant accounts for a period of 3 years and that fact has been advertised as required under subsection 4, the balance on the account shall be transferred to an account earmarked for that purpose at the Bank of Ghana. 7. Where a balance has been transferred under subsection 6, the Bank of Ghana shall, on a request, refund any unclaimed balances to the depositor, or if the depositor is dead, to the legal representative of the depositor. Section 156_interpretation section. Bank means a body corporate which engages in the deposit taking business and is issued with a banking license in accordance with this Act. Deposit-taking business means the business of a. Taking money on deposit and making loans or other advances of money, and b. Financial activities prescribed by the Bank of Ghana for purposes of this definition. Done.